Good morning, everybody. This is the South Coast AQMD Hearing Board. Today is February 7th, and we have before us today, I'm going to go ahead and read the entire agenda. We had Energy, or is it NER Holdings? There's no G there. Enery. Okay, Enery Holdings, LLC, and that has been rescheduled and is off the calendar. And we also have today Bristol Industries, case number 5017-2 for a regular variance regarding rules 203 and 1124. And then after that, we will have Henkel U.S. Operations Corporation, case number 4818-1. And that will be for an emergency variance regarding rules 203, 2004, and 3002. So let's go ahead and start with Bristol. However, I think I'm going to ask both parties if you're okay with Mr. Pearman participating. He was not here for the interim, but has, I think, come up to speed on. Did you want to make a statement, Mr. Pearman?
Not really, but I read the petition, I read the manual, I read the exhibits. So I'm certainly prepared to rule today.
Thank you. Okay, are there any objections to him participating?
No objections.
Thank you. All right.
I think you only value also.
Oh, okay, Mr. Ali. And is there any objection to Mr. Ali participating?
No objection.
Thank you. All right, so with that, who is here on behalf of Bristol?
Brooklyn Hildebrandt. I'm here as counsel for Bristol, and I can spell that for the clerk now if she would like. Brooklyn, Brooklyn, Hildebrandt, Hildeb as in boy, RAN as in Nancy, D as in dog, T as in toy. And I will let Bristol represent or speak to who they are today.
Richard French, Bristol Industries environmental team leader.
Bruce Armbruster, directing consultant with All For Environmental, BRUCEARMBRUSTER.
We also have Hong Gao available.
Yeah. Hong Gao, plan manager for Bristol Industries.
Okay. How are you spelling your last name, ma'am?
It's HONG and last name is GAO.
Thank you.
And the title?
Plant manager for Bristol.
Okay, and on behalf of the district?
Senior Deputy District Counsel Ryan Manzel on behalf of the Executive Officer. Along with me is Supervising Air Quality Engineer David Louie.
Air quality engineer, correct?
Supervising Air Quality Engineer.
All right. I believe that we have some exhibits to mark that we just received, and the first one, which is the work schedule, will be marked number 3. The chronology of events will be 4, and the purchase order will be 5, all on behalf of Bristol. And then on behalf of the district, the proposed regular variance conditions, and that'll be marked as B as in boy. Okay, and all those who are going to be witnesses, if you can please stand and raise your right hand. Okay, do you swear under penalty of perjury that you will be telling the truth, the whole truth, and nothing but the truth? Okay, thank you. All right, with that, let's go ahead and start with opening statements. And Ms. Hildebrandt.
Thank you all for this meeting here with us this morning. My name is Brooklyn Hildebrandt. I am counsel here on behalf of Bristol Industries. We were last here on December 14th for the hearing on the interim variance, which this board granted. And I would just like to go ahead and move to incorporate those proceedings from the 14th as part of the record for this hearing.
Thank you. So moved.
Thank you. So we were, just to recap, I know, at least for members Ali and Perman who were not here last time, we were here in December for an interim variance after an incident basically rendered the regenerative thermal oxidizer at Bristol Industries Brea plant inoperable. Because of the inoperations of the RTO, the regenerative thermal oxidizer, but I will refer to it as RTO for the purposes of this proceeding. About 80% of Bristol's production has ceased. It was not able to operate about 80% of its processes without the RTO. So we sought and received the interim variance. We are here today seeking a regular variance. We are asking for a 5-month regular variance. As you can see from exhibits 3, 4, and 5, really all provide a chronology and somewhat a little bit more organized, but we are hoping to have the RTO fully repaired within 12 weeks. We are seeking a longer period of time just in case something happens and we need longer to repair that RTO, and that we do not have to come to the board again under an interim or emergency hearing. Although again, ideally we will have the RTO up and running and only need to use the regular variance if granted for a period of about 3 months. So to get started, I do have with us both Richard French, who's in charge of operations, and Hong Gao, who's the plant manager for Bristol. They spoke last time, and I brought them here again today to speak today if the board has questions. But we do not intend to present additional testimony. And then Richard Bruce, he is a consultant from All for Bristol Industries, also here today, and can speak to the work that has been done during operations under the interim variance and the operations that will occur under the regular variance. So just to get started, without the regular variance, or essentially without any ability to operate, about 80% of Bristol's facilities would be inoperable, which is ultimately a practical closing of Bristol's facilities. This would impact its processes, as well as staff and personnel who work at the facility. Ultimately being in violation of both AQMD's regulations as well as its own operating permit if it were to operate without a regular variance. Again, requiring compliance here would essentially shut down 80% of its operations. So it's like basically a near total prohibition on the facilities that would result in the closing of Bristol's otherwise lawful business due to conditions that are beyond their control. Again, we are here today because of an incident that occurred back in November, causing the RTO to become completely inoperable. Since then, Bristol has completed a root cause analysis to determine exactly why the RTO stopped working, and what to do to bring the RTO back into service. This, as you can see from the purchase order, this has already been, we've been working with the manufacturer of the RTO to bring the RTO back into service. And this includes a number of new safety alterations to ensure that the RTO is not only operating efficiently and effectively, but also incredibly safely, so that we do not encounter a situation like we did in November again. Closure of Bristol's business without a regular variance would have no corresponding benefit to emissions, as the processes that Bristol engages in are the same processes at other facilities in nearby communities. So most likely the customer would just find someone to service their needs elsewhere. Bristol has given consideration to curtailing its operations in lieu of a variance at all. And that is, if you can see, I know it's Exhibit B, but for the proposed conditions, conditions 1 through 4 really show those decreased operations. We will not be operating at full capacity under conditions 3 and 4. It's an incredibly limited set of operations. And if this board does have questions about, there's a few changes between the interim variance and the regular variance. These are really due not only to a few things that, kind of slipped through the cracks during the interim variance, and we tried to operate without certain materials and lubricants, but found it didn't make sense. And so using outsourcing and the limited usage under the interim variance, of the 80% that we had lost, we were able to get back about 30-ish% of operations. But we experienced approximately 50% failure rate for all of the materials that went off-site to an external source to do certain spray coatings and curings, which basically meant that we were operating at a near loss because we were having to recure and recoat some of those products and use the limited materials that we did have to a second round, essentially, of these products. So again, we have given much consideration in this to curtailing those operations, and we've worked with AQMD to find a steady solution that works for this. Regarding the reduction of excess emissions to the maximum extent feasible, again, we've worked with AQMD on these usage conditions to curtail emissions, and ideally, again, we will be operating only under this regular variance for the next 3 months until the repair is complete. And finally, Bristol will continue, and it has been, will continue to monitor and quantify emissions levels if required by the board, and it has done so under the interim variance. This is done internally through the recording of the Form 109s that the refineries put together on a biweekly basis. And we have those as well if the board would like to see those. And then regarding future compliance with a regular variance, we have submitted various reports to AQMD in accordance with the interim variance. And in regards to this board's concerns during the interim variance hearing, also, we have not received any odor complaints during the operation of the interim variance at this time. And I will just say again, we do have everyone here who participated in the last proceedings who can answer any questions about, if you have additional questions regarding the root cause analysis or the purchase order. But their chronology also goes into detail everything that has basically been done between the interim variance and now to diligently try to get the RTO up and running. And with that, I will close my opening statement.
Thank you. From the district?
Thank you, Madam Chair. Good morning. The executive officer has reviewed the reports submitted by the petitioner pursuant to the interim variance conditions, as well as the proposed evidence that the petitioner will be offering today. On that basis, and assuming that the hearing board adopts the proposed stipulated conditions offered by the executive officer, I anticipate that the executive officer will come back to you at the close of evidence and not be opposed to the granting of the regular variance. Thank you.
Okay. All right. With that, let's go ahead and if you wanted to present any of your witnesses.
Do you want to answer a few? Yeah, I will just ask Richard French a few questions just so we can kind of go over some of the exhibits you all have in front of you, if that works. So Mr. French, I'm looking at exhibit 4, and this is the chronology of events from issuance of the interim variance on December 14th, 2023. Could you just walk the board through what Bristol has done since the interim variance? But specifically with regard to the RTO and getting the RTO back online.
Please turn your mic on.
Madam
Thank
Chair,
you.
just for the record, I think you should state his name and position and where they took the oath.
Yes, and the fact that you took the oath, like asking it again.
Okay. My name is Richard French. I'm the environmental team leader at Bristol Industries. And I took the oath earlier this morning with the rest of the witnesses to present to this hearing.
Thank you.
So if you could, sorry, Mr. French, if you could just walk the board through, this is Exhibit 4, the chronology, specifically with regard to the RTO.
With the RTO, after we completed the root cause and corrective action analysis with our consultants and looked at upgrades and what we were going to be adding to the for safety on the RTO with our vendor and our consultants. We requested quotations. We received the quotations. We input the, due to the amount, the appropriate internal justification paperwork, pushed it through the system and issued the purchase order for that on February 2nd.
And Mr. French, is that Exhibit 5?
I'm sorry?
Is that Exhibit 5?
Yes, that would be Exhibit 5.
Thank you.
Thank you.
Mr. French, looking then at Exhibit 3, this is a copy you prepared of the estimated work schedule from Alliance, is that correct?
Yes, it's an estimated work schedule based on what I received from our maintenance team pulled from an email from Alliance in the interpretation of their work schedule.
And do you know when this work is or got scheduled to begin, or has it already begun?
As I understood it, it was to begin on Monday. However, being as though the RTO is on the exterior of the building and we had inclement weather, the work should be starting today.
Thank you.
Okay, before we change
Oh.
witnesses, we need to let the district ask questions and then the board.
Sorry, apologies.
Okay, does the district have questions for this witness?
Just a couple questions. Mr. French, what is the projected timeline for when the repairs will be completed in a best case scenario?
In a best case scenario, we're looking at 12 weeks.
And once the repairs are completed, will Bristol Industries facility be operating pursuant to the ordinary terms of its permit?
That is correct, yes.
I have no further questions, Madam Chair.
Thank you. Okay, I had one question. You had mentioned that the incident was in November, but it's not in the timeline. In your opening statement, you mentioned November.
Yes, apologies. I believe we presented another chronology that is Exhibit 1 or 2 last time. The chronology that we presented as Exhibit 4 is just since the interim variance
From
hearing.
that point forward.
Yes,
Okay. thank you.
apologies.
All right. Mr. Balagopan, did you have questions?
Yes, Mr. French, good morning. At the last hearing, I think there was, I think from what I remember, it was your corporate who said, don't start it because, they wanted a root cause analysis done. And the initial assumption was there was some ductwork that was loose and so forth. But it appears from, and I know we didn't get the board didn't get a copy of the root cause analysis. We didn't ask for it, unfortunately. I don't know if you have copies to hand out or not, but nevertheless, what were the main findings from the root cause analysis?
It appears as though we had a faulty valve on the fuel blending train into the RTO. where the natural gas is introduced into the air inlet stream from the process air to assist in the combustion. And the RTO had been shut down the night before, and then the next morning, enough gas had collected at that point that when the ignition sequence started for that morning, we ignited the natural gas in the inlet tube in the process air inlet. And there was also a fault in the valve for the fresh air flush to draw in for the purge.
We heard testimony, there was some issues with the operator error. Basically, there was a warning light that went on indicating, there was a problem with the loop oil. Was it?
The warning light that was on there, or the alarm on the screen, was due to the air flow sensors going through an automatic calibration, and the restart button was pressed before that could be finished, and that must be done with zero flow.
So that has been corrected and the operators have been trained not to take proper action.
That is correct, sir. And that's also being addressed in the corrective actions with the repairs in the programming of the PLC system.
Okay. So looking at this, so the root cause recommended repair of the air inlet valve, which is what you just mentioned, then the sensors, and then valves. Is that the poppet valve, or is it or what are the valves? And then the software installation repair and shell repair. So it seems like there was a lot more going on than just the ductwork being displaced and so forth.
Correct. When the explosion occurred, it bowed out the plate that accessed the process air damper valve, and also the air inlet for the fresh air for the purge valve, indicating that the explosion was in that area and going out to the ductwork, and the concussion of that knocked the ductwork off the mountings.
So did the explosion cause any damage to the beds? You have a regenerative thermal oxidizer, correct?
Correct.
2 beds or 3? 2.
2 beds.
It didn't damage the beds or anything like that?
Based on the examination, the only damage was possibly from the concussion to 10 by 10 by 10 blocks of the insulation block were knocked off the wall, and they all have to be re-adhered as part of the repair.
Okay. Prior to the explosion and prior to the mishap, were you having any difficulties reaching the 1500 degrees?
No, in fact, the system itself is operating at between 1590 and 1605 continuously. And prior to the explosion, it had been running for 16 days straight. 15 days, I believe.
So the unit is shut down and will be shut down, and you will not operate it, the RTO, until all the repairs are finished, and you will do it, correct?
That is correct.
Okay. But you will still be spraying without it being in the spray booth?
No, we will not be spraying. We will be immersing, applying the lubricant by what we call our dip and tumble method.
Okay, sorry. So the dip coating type operation?
Yes.
Okay. And then I noticed that there's a change in the condition on the, are you familiar with the proposed condition?
Yes.
And previously there was no limit on the pounds per day. So it does say now does not equal or exceed 58 pounds per day. Right?
Yes.
Okay. Actually, do you have the condition in front of you?
Yes, I do.
And it's something I didn't catch last time, but condition number 1, it says petitioner shall not perform any spray coating operation in this equipment. When you say in this equipment, I mean, the equipment for the variance is the RTO, but the spray coating operation, basically it's not spray, the dip operation.
It would be
In
in,
the,
in the permanent total enclosure associated with the RTO.
oh, okay. So that's why this equipment, the PTE associated with the.
Correct.
Okay. Okay. All right. I guess we don't need to clarify that, but I think that explains it. Okay. And as far as excess emission, are you familiar with the calculation for the excess emission and how much previously, or is it somebody else who can answer the question? And we can wait for Mr. Armbruster's turn here. If you don't know,
I'm not that familiar with the excess calculation or calculation of excess emissions. I've just been calculating emissions.
okay. And the other one was to look at temporarily bringing in a carbon absorber to to control those emissions. And what have you found out since then?
Every firm that I made contact with for either or for the rental carbon absorption bed indicated that they'd be glad to sell us one, but they didn't have anything available to rent, and especially nothing available to rent with a variable site permit.
And final question for you is, when is the end, and I'm sure it's here somewhere, you're requesting the variance relief until what month? And
I believe we're looking at July 9th as the end date for the variance.
okay. And that's sufficient time for all with the delays. I think you say 5 weeks, right, in your,
We are looking at 12 weeks, which would put us at sometime late in May. But what happens if product that has long lead time has a longer lead time? We're trying to mitigate that in the application so that we're not returning to you at the end of May saying we need another 2 weeks.
all right. That's fine. Okay, thank you. I have no further question. Thank you, Mr. French.
Okay,
You're welcome.
anyone else, Mr.
Yes,
Pearman?
Madam Chair, just a quick question. You'd have referenced the chronology, and I went into the file. I didn't see a chronology uploaded.
From the previous
From the previous.
interim hearing?
So it was provided to the board on December 14th. So it should have been uploaded December 14th.
It should be there, unfined.
Here,
And
right.
it's not there.
So
It was-
perhaps if you can,
No, it was provided, it was marked as Exhibit 2.
yeah, but that exhibit should have been uploaded here. So
It was uploaded on the page. For that page, if it's not leaving there now, I'm not sure on that, it was assumed.
I do see it on the website.
And, all the documents have not been put in as an exhibit yet. I haven't completed this one.
okay,
I do see it as exhibit petitioners 2 on the assigned.
where is it? I'm looking here.
On the page number and the documents I have is petitioners exhibit
Off of the
2.
agenda or unfined?
On fine. Yeah. Number 2.
Okay, all right, no problem, thanks.
Okay. Mr. Pearman, you had a question?
So first, Bristol does agree and therefore these are stipulated conditions as set forth in Exhibit B.
I'm sorry, sir, could you repeat that?
Well, for you, counsel, so you stipulate to the conditions proposed in the district Exhibit B.
Yes.
And the reference to the temporary carbon absorber, your chronology, and as you stated, shows you've made efforts and have not found one. So why the extra 30 days and what is the final determination steps that haven't already been concluded that you think might happen in 30 days to change your position?
Is that going to be answered by another witness?
Yes, that would be
Okay,
best answered by my colleague, Bruce Armbruster.
All right, thank you.
thank you. All right, any other questions for this witness? All right, seeing none, you can go to your next witness.
Just really quickly, I do have copies of the report submitted to AQMD if the board would like copies of both of those.
Are you talking about the root cause analysis or?
The root cause analysis is described in the January 12th report, if that would be,
I think so.
okay. So I'll mark there's a January 12th, 2024 report as Exhibit 6, and then a February 2nd, 2024 report as Exhibit 7.
Okay, great.
When you can, email us to the clerk so they can post it for the public. Thank you.
And carbon. So permanent one might be just outside, so just in case. Yeah, just exhaust everything, right?
Okay, so the letter from Mr. Liu is marked as 6, and then the letter from Sidley is marked 7. Okay,
Thank you. And then, Mr. Armbruster, if you would go ahead and restate your name, position, and whether you took the oath this morning.
Sure. Bruce Armbruster, Directing Consultant with All Four Environmental. And yes, I was sworn in and took the oath earlier this morning.
And Mr. Armbruster, you are assisting Bristol with excess emissions calculations and their compliance with this variance hearing, is that right?
Correct. We are assisting them through navigating through the overall compliance approach as they pursue this variance and the return to operation for the RTO.
And could you just describe for the board how you've worked with them on the excess emissions calculations for purposes of this hearing?
Sure. So in determining and looking at the excess emission calculations, we looked at historical usage and projected usage of the various coatings that were associated with the dip and spray coatings conducted in the PTE that's vented to the RTO, which is the subject of this regular variance hearing. In taking that data based on the throughputs and recognizing that there was an effort that needed to be made towards mitigating some of those emissions with the RTO not in operation, the idea was to figure out if some of that work could be transferred to a third-party offsite contractor for some of that coating. And so a part of the mitigation was to reduce the overall coating and salt consumption in the PTE that's vented to the RTO during this variance period and basically supplementing that through a third party. So what we see in the excess emission calculations, the portion that they don't believe could be transferred to a third party, then adjusted for what the controlled emissions would have been if it would have been vented to the RTO. That difference is what we calculate as the excess emissions for the purposes of this variance period.
And then if you could look at condition 8 of the stipulated conditions, this is one of those conditions that we had in the interim variance, but it has since changed. I guess, could you just walk through what is there potentially left to do with regard to trying to find a temporary carbon absorber during the regular variance?
Right. And this addresses Mr. Pearman's comment or question that was proposed to Mr. French. And it's really related to the fact, why is this condition here? Have we not already exhausted the pursuit of a third party or as a carbon absorption system with a multi-site permit? The idea is that we believe we have exhausted it, but we don't want to give up on it prematurely, knowing that something could occur. And so we're going to continue to pursue that in good faith during this regular variance period.
Thank you. Those are all the questions I have.
and from the district, any questions?
And I don't know if this will be for another witness or not, but there are some additional materials in condition number 4 that were added to the proposed stipulated condition for the regular variance as compared to the interim variance. Is that right?
That's correct.
And could you identify what those additional materials are?
Yes, these are three materials, the BPS 454, the BPS 470, and the thinner that's used in conjunction with those materials. These are proprietary blends or formulas that are used by the facility. And initially, during the establishment of the interim variance, the hope and thought was that because these were lower volume materials and not particularly tied to their high use materials, that they could get by through the interim variance period without including them. But subsequent to entering into the interim variance, they obviously have not been able to meet the customer demands for these coatings because they haven't used them during that period, but in addition have obtained or received additional orders for materials that require these coatings. So in order for them to continue to function during the regular variance, we have requested that they be added back in to the conditions of allowable materials to be used. The one concern with these materials, and they cannot be outsourced because of the proprietary nature of those formulas, they must be conducted in-house, or the coating process using these materials must be completed in-house.
And if you could just briefly describe what was the end result of the interactions with the third-party vendor that was sort of tapped to potentially offset some of the coating that was done at Bristol's facility?
Yeah, and again, I think that Ms. Gow can probably comment on this also, but what we learned was that by sourcing the coating process to a third party, there were issues with their ability to complete the process in a manner that would meet the standards, the quality standards that Bristol must meet for its customer. And in fact, they have seen a rejection rate of close to 50%, if not exceeding 50%, in the materials that they had to send out. So obviously, within that process, that creates another obstacle because now they're not only unable to meet their customer demands in a timely manner, but the materials that were coated have to be stripped and reworked, which essentially actually results in more emissions during this process because of the inefficiencies created by the third party.
And I have no additional questions, Madam Chair. Thank you.
Thank you. Board members, any questions for this witness? Mr. Balagopalan?
Morning, Mr. Ambrose.
Morning.
With the addition of the three additional coding, are any of them subject to Rule 1171?
No, not in this case, because they would be subject to Rule 1124.
Okay. And so now there's the condition number 4 is revised also to say not exceed 58 pounds. Is it based on the addition of these three compounds?
Yeah, the idea in this case, because previously in the interim variance, there was a daily limit on the volume of each coating identified as being allowed to be used during the interim variance. And in order to allow the facility to have more operational flexibility during the regular variance, we took that emissions profile that would have been generated by those coating volume limits and converted that to a VOC, a daily VOC emission limit. And as long as they operate under that daily VOC emission limit, it's the same general air emissions profile, and it gives them more operational flexibility to be able to respond more agilely to client or customer demands.
And that will be reflected in the form, the VOC record keeping form?
They'll continue to maintain records of each coating and solvent used, and again, it will be a part of the responsibility will be on Bristol to make sure that they maintain the proper mix of coatings and solvents as approved to maintain compliance with the proposed daily VOC emission limit.
And I think I heard Ms. Hilbrand saying there were no odor complaints. Were there any odor complaints or were there 3 or more, to your knowledge?
Not aware of any odor complaints during the interim variance period.
Okay. Yeah. All right. And that is directly to the facility. But did you hear anything from the district about any odor complaints?
No, in fact, it's our understanding that enforcement or the compliance division visited the site or at least spoke to the site regarding their compliance with the interim variance conditions this week, and they found no issues.
Going back to condition, the proposed variance condition exhibit B, I was going to propose a change just to be clear and wanted to get your input on it before, check with the district. So instead of saying spray coating, because you're not doing spray coating, just say coating equipment.
Well, let me clarify that. So within the potential or the permanent total enclosure that's vented to the RTO, there is a spray booth that they can do spray coating in.
Okay.
So what they're doing in this case, they've eliminated the spray coating operations and they will continue to do the dip coating. So that's why condition 1 specifically identifies the prohibition on spray coating. They're limited. So that's another way to mitigate emissions. They're limited to only dip coating.
Okay. And so in this equipment, whether it should be clarified to say in the PT associated with the RTO, the permanent total enclosure.
That would be fine. It should clarify the equipment, what the equipment is.
What the equipment is, so,
Okay, so you're changing number 1, the verbiage on number 1?
Yeah, just to clarify that the petitioner shall not perform any spray coating operation in the permanent total enclosure, parenthesis PTE, associated with the the regenerated thermal oxidizers of the RTO.
Madam Clerk, were you able to capture that?
I do have that, Madam Chair, but I guess once it's all agreed upon, if it could be stated
Okay.
when we do the closing.
Madam Chair,
Yeah, wanted to.
Yes.
if I may just weigh in, just to be accurate, and to clear up the confusion about what is this equipment. So when this condition was crafted, it was to sort of align it because they are asking for a variance from their permit to operate. And there, the reference is to this equipment, which is the air pollution control system. And that air pollution control system includes the total enclosure with all of the equipment. So I think just for consistency's sake, for anyone who happens to be viewing both the permit, the petition, and the conditions together as a complete unit, that the reference, perhaps instead of this equipment, should be, shall not perform any spray coating operations in the air pollution control system, just so that it is aligned with what is designated in the permit to operate.
Is that satisfactory,
Yeah,
Mr.
that's
Ballard?
better. I think it does refer them
Okay.
to the permit.
Thank you for that. Okay, any other questions? Board members for this witness? All right, okay, let's go to the next witness, please.
I'll just ask Ms. Gao to again state her name, her position, and whether she took the oath this morning.
My name is Hong Gao. I'm the plant manager for Bristol Industries. I took the oath early in the morning.
Thank you. And Ms. Gao, I'd like you just to speak. I know when you were here last time, you spoke about the impact that the lack of a variance would have on operations, specifically to like what is the impact of the closure of the RTO?
Okay. So previously in the interim variance session, I have stated our business, serving to the aerospace industries, a lot of what we do are specifically associated with certain material, and the RTO or some of the coatings services were provided through RTO, the regenerate thermal oxidizer, is to enhance the product performance. Without RTO, essentially roughly close to 80% of our product just cannot get processed. Or if we don't have that process, we will not be able to meet our customer product requirement. They have specifications we must meet. This is why previously we were here for the interim variance to hopefully, essentially without RTO, our business will be at a halt state. We not only we would damage our halt our service, reduce our capability of service customer, have significant delays, especially as you can see, some of the proprietary information, services we provide does serve into special, customers' requirement. And without that, essentially, even our customers' product line will get affected. This is the reason why last time we were here for the interim variance. And after the interim variance granted, we've, as Bruce introduced and, Brooklyn questioned, we were essentially getting about more than a little over 30% of our business down with the interim variance. We were encouraged and hopeful to utilize the OSP, outside service provider, to assist in another 30-ish% of the business. And unfortunately, due to their lack of knowledge of the particular coding service need to provide it, and also specifically, they do not understand the product and our, specific, and therefore, their quality of the service provided were not at the optimal level we're looking for. Essentially, we have the record since December 14. We've experienced close to 50% of the rejection rate. With that, not only increase our rework cost and also causing additional long wait, additional rework cycle, essentially even compounded further into our already limited interim variance. So we are still in the significant constraints of fulfilling our customer obligation, and definitely we're already incurring significant costs into the business of able to operate as a profitable business. Yeah.
Thank you. And then just one last question, then I will hand it over to Mr. Mansell. With the change in the conditions from the interim to the regular variance, is that because you're hoping that it will allow you to increase the level of business you're able to get back without reliance so much on an external source?
Yeah. That's absolutely one of the significant costs because, our employees or our, operators are trained to perform these type of service, for many, many years. So they're expert. We're hoping by increase the variance level, we're able to operate close to normal. Yeah.
And that's all I have.
Thank you.
I actually do have one more to add, if you may.
Actually, can I have one more question?
Yes,
Thank
go
you. Go ahead, Ms. Scott.
Yeah.
To the board, if you can.
Yeah. Oh, I'm sorry. I just want to keep highlight on these spray booths we have. It's currently in the tagout condition, so we make sure it's not operable.
Okay, thank you.
Thank you.
Mr. Mansell?
No questions for this witness. Thank you.
Okay. Board members, any questions for this witness? Mr. Balagopalan?
Ms. Hall, sorry, did I pronounce your name?
I have one question while he's looking for that. How many customers has this affected?
What I could say is more than 80% of the customer get affected.
Well, I understand the 80%, but about how many customers?
We have some major OEM.
Mm-hmm.
Each customer could weight very heavily. I would say if I evaluate, more than probably 60 to 70 different type of customer get affected.
Okay,
Yeah.
thank you.
Some are very large OEM.
I understand that, yes. Thank you.
Thank you.
Mr. Balagopalan.
Thank you. Madam Chair, Ms. Gao, previously in the petition, there was it was stated there was an option to rent a 3,000 CFM oxidizer model RTO from Alliance Corp to allow partial use of the process. But however, that due to permitting timeline, this was not seen as a feasible option. What is the situation then now that you're getting a regular variance until July? Is that, do you know if they have a various location permit or what?
Probably, Bruce can help us to answer that question better.
Okay,
Yeah.
well,
Yeah.
and then the other question I had was on the root cause analysis indicated there was a problem. So there was not a LEL sensor before for the process stream?
Correct. From the vendor, admitted they did not have the LEL sensor designed at the initial stage. And with this root cause analysis and believe the corrective action should include it to prevent further potential incident.
And when you say the inlet, process inlet, you mean process the stream with all the VOC?
Correct.
Okay. And then the other safeguard, which was what happened last time, was that the purging didn't occur. So you're adding a sensor and a sequence to.
Correct.
Now, what is the position switch and how does it say fully open, fully? What does it do?
Because I've been participating every single meetings, right? It was identified, maybe earlier you indicated potentially it's a operator error. In our mind, the operator error, if we have a mistake-proof type of system, we should create an environment regardless whether operator go push the button or not. The system should not allow the button to even take the effect. So in this time around, the corrective action will include not only the sensor, and also making sure the PLC will have a program preventing if the system is in the fault situation, it will not start regardless who is doing what.
Operator proof.
Correct.
Okay, thank you. No further
Thank you.
Thank you. Okay, any other questions for this witness? All right, and that exhausts all of your witnesses. Okay,
Just had a follow-up for Mr. Ambrose.
go ahead.
And that's regarding the renting of renting of the oxidizer from Alliance Corp.
Yeah, so again, it doesn't have an existing multi-site permit associated with it. So in order to do that, it would still have to go through the permitting process. And so that in itself, the district could probably comment on what that timeline might look like. But that would, again, be additional delays.
So they have a unit, but they didn't get a permit for it?
It's one that they had in-house, that it was basically a return and that they could allow them to use. So that's why.
Okay, all right. Thank you.
Any other questions? Okay, and that's all of your witnesses, correct? Okay, Mr. Manzel, did you have any witnesses you wanted to present?
I don't have any witnesses to present. The only thing that I would mention is I did just refine the language for that condition number 1. So at the time the board is considering those modifications, I'd just like to suggest the precise language for that. But
Okay,
otherwise, no, I have no witnesses. I do have our supervising air quality engineer available if the board does have questions, but I do not intend to affirmatively call him at this
okay,
time.
thank you.
Thank you.
Any questions for the engineer, Mr. Balagopalan? Okay, all right. Do we have any members of the public who have their hand raised or had wanted to make a comment or provide testimony?
Madam Chair, there are no hands raised for members on Zoom. I've not received any cards, and it does not appear that there are any members in the public, in person with testimony or comments.
Okay, thank you. All right, with that, we can go to closing statement. Ms. Hildebrand?
Thank you, Madam Chair, and the board as well. So just to very quickly recap and not spend too much time with you all this morning, I know there are 6 findings that the board needs to make to issue the regular variance. And I think, at the outset, Bristol has worked incredibly diligently since we were last here in December to work on identifying a root cause of the incident on the RTO. And I've been working diligently on that repair timeline. And so again, we are asking this board to make those findings in support of a variance until July 19th, caveating, of course, that Bristol very much hopes to be utilizing and operating under its regular permit as soon as possible. But just once again, so first, the variance, or without a variance, Bristol will be operating, if it were to choose to operate without a variance, it would be in violation of AQMD's rules as well as its own permit. The incident that occurred in November on the RTO was beyond the reasonable control of Bristol Industries, and it has worked diligently to combat those and to, halt its operations without a variance at this time. Would cause the practical closing and elimination of 80% of its business, which 80% is really practical closing for all intents and purposes for this type of industry. There would be no corresponding benefit in emissions reductions by failure to provide the interim condition. And not only has the applicant given incredible consideration to curtailing its operations, but it has indeed curtailed its operations significantly under both the interim variance and moving forward, hopefully, under the regular variance. While the variance is in effect in conjunction with conditions 3 and 4, Bristol will continue to mitigate excess emissions as much as possible. It will, of course, pay those excess emissions fees as necessary at the closing of its use of the regular variance if granted, and will continue to monitor and report and quantify those excess emissions and its usage limits, and will continue to keep AQMD and this board, as requested, apprised of its progress during that time. Thank you.
Thank you. Mr. Manzel?
Thank you, Madam Chair. The executive officer, having heard the witnesses and viewed the exhibits in evidence, and on the basis of the 6 findings that this board will have to make, and assuming, of course, that the board adopts the proposed stipulated conditions, the executive officer does not oppose the regular variance. Thank you.
Okay, we can start deliberating. Anybody wanted to begin? Mr. Pearman?
Well, I'd just like to hear what district council has for the language in 1 that they want to amend before we start.
Yes, so I did also send the proposed language to the clerk of the board's email address because it does include some additional punctuation, which of course, when read aloud, can sometimes make things confusing. But the language in full for the condition would be: petitioner shall not perform any spray coating operations in the air pollution control system, open parenthetical, APCS, close parenthetical, comma, permitted under AN 632693, comma, until the APCS is regenerative thermal oxidizer, open parenthetical, RTO, close parenthetical, is fully repaired and is in full operation. And again, looking at the permit, the air pollution control system includes the RTO, the exhaust system, and then the lube room, permanent total enclosure, and all the spray booths. So that term should encompass all of the equipment and the spray coating operations. Thank you.
Thank you. Okay,
I have nothing to add. I think the applicant has set forth all the 6 findings with evidence both in writing and by the oral testimony, and that we could issue the ruling appropriately.
thank you. Any other comments, board members? Mr.
No, I
Balagopalan?
agree. I think the 6 findings can be made. As indicated, they are in violation of Rule 1124 and some of the associated permit conditions that were previously listed. And and they have, I think what we heard last time in the interim variance was the corporate and was was adamant that they do not start it until the root cause analysis was conducted. And turns out that was probably a good thing because now they found out they've taken other corrective action, adding more sensors, and so make it so that a similar incident doesn't occur again with the safety and the switches and the sensors and the positioning of the inlet air, purging the system before starting up. So I think those are all measures that, as a result of good cause finding, and they're going to install all that is identified, and they will need the time to do that. And I think July, while they're asking for July 9th, hopefully it'll be done prior to that. And I think the excess emissions previously was stated as about 43 pounds, I think. So since they're asking not to exceed 58 pounds, so it's anywhere from 43, 58 pounds a day. But I think their submittal will reflect that. Its VOC and excess emission will be approximately 58 pounds per day on the high end. And they have given consideration, as we heard, and looking at renting, and they've not been able to do that. So for all those reasons, I do believe we can also grant the regular variance, subject to the revision that Mr. Menzel cited, on the length to the Exhibit B, condition number 1, the revised language. Just to clarify, I wasn't trying to be picky here, but when I first read it, but I think he's right. It does refer in the whole application, the PTE, not just the RTO. So I too can make the 6 findings.
Okay. But before you do, I just want to offer my comment as well. I also can make the 6 findings based on the testimony, and especially the fact that you're dealing with proprietary blends, which I know that you are want to be very careful of, and not being able to go to that third party and having a 50% failure rate when you did. So I can understand how it would take that much more time to be able to accommodate the specific customers that you do have that require that specialty product. So I also can make the 6 findings, but go ahead, Mr. Balagopalan.
Well, before he goes on, there's 2 of us over here as
Oh.
well.
Okay, go ahead.
Yeah, I'd concur with my colleagues that the 6 findings were made. Thank you.
Okay. All right, go ahead, Mr.
I don't
Balagopalan.
know if Mr. Abraham wanted to make the button,
No.
because he did the last time, so. So I'll go ahead and make the motion. Yeah, so in the matter of Bristol Industries case number, got it all over the place now, 5017-2, I move that we grant a regular variance starting today and ending on July 9, 2024, for the equipment listed in application number 63632-693, for the facility located at 630 East Lambert Road in Brea, California 92821. And the conditions are as listed in Exhibit B, with the changes that was read and provided in the email by Mr. Mansell to condition number 1. And the excess emission during this period will be approximately 58 pounds per day of VOCs. With that, I conclude my motion.
Second.
Okay, any discussion on the motion? All right, let's take the vote. Mr. Ali?
Aye.
Dr. Abraham?
Aye.
Mr. Pearman?
Aye.
Mr. Balagopalan?
Aye.
And I also vote aye. And so it's unanimous. Thank you very much for coming today, presenting your case, as well as working with the district. Thank you to the district as well, all the staff that I know that work together with Bristol. So this is, I think, a very good outcome, and hopefully you can get everything done and accommodate your customers. Thank you very much.
Thank you, Madam Chair.
Okay.
Thank you, Board.
Let's go ahead and take a 15-minute break. We are off the clock. We're back on the record. Start the recording, please. Thank you. Okay. All right. We have the next case, which is Henkel U.S. Operations Corporation, case number 4818-1. This is an emergency variance, rules 203, 2004, and 3002. And who is here on behalf of Henkel?
Good morning, ma'am. My name is Alfonso Graves. I am the SHE manager, which is Safety, Health, and Environmental Manager at Hinkle, and I have two others with me.
Okay, and you want to spell your name, sir?
Oh, it's Alphonso. Last name is Graves, Graves.
Okay. All right, and on behalf of the district?
Good morning, Josephine Lee, Senior Deputy District Counsel on behalf of the Executive Officer.
All right, and we do have some exhibits. We have the timeline from Henkel, and that is Madam Clerk verifying as number 1? Yeah. Okay. And then we also have the proposed variance conditions coming from the district, and that will be A as an apple. All right, and you are going to be presenting your witnesses. How many? 2 witnesses?
Yes, ma'am.
Okay, and have they taken the oath already this morning or not? Okay, if you can please stand and raise your right hand, please. Okay. And do you swear under penalty of perjury that you will be telling the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Okay. All right. Let's go ahead then and we can start with your opening statement.
Good morning, Board. I am Alfonso Graves. I am the Environmental Health and Safety Manager at Hinkle. And on Wednesday, January 24th, Wednesday, it was brought to my attention that the RTO, which we use as an air pollution control system, was not operating at the proper temperature. So I bring that into because there are some NOVs that are associated with my permit, but the NOVs are totally separate from what I'm doing today. The NOVs are basically for reporting period. This is for a temperature period. So my asking for a variance has nothing to do with those NOVs. And so when it was brought to my attention, I then brought it to the plant manager's attention of the condition, which states that the I will refer to the regenerative thermal oxidizer as the RTO, that the RTO cannot operate if it is not operating at a temperature of 1600. So on Thursday, the temperature would, the average temperature was 1413, so it was decided not to run the unit at all that day. Friday was the same thing. It would not reach the permit condition of 1600, and so we did not run operations at all. At that point, because of the business impact, I suggested that we get a emergency variant so that we could operate. As you will see also, a root cause analysis was done on Friday, and it was determined that the chambers or the beds in the chamber and the media had been compromised. So on Monday, the RTO was started at 3 a.m. and it reached an average temperature of 1520. And then on Tuesday, it also reached a temperature of 1530. On Wednesday, the 31st, the parts that were ordered came in and the RTO was taken down for repair. It was down for 6 hours, 27 minutes and 12 seconds. Thursday, it was at midnight to 6 a.m., it warmed up and it reached an operating temperature of 1629. Friday, it also reached a temperature of 1606. And then Monday, it reached a temperature, the average temperature was 1610. I am asking for a variance that would have started on the 29th because those are the 2 days that the RTO itself would not reach the operating temperature of 1600.
Thank you, sir. Ms. Lee?
Yes, good morning, Board. For the first part of today's hearing regarding good cause and whether the facility exercised diligence in petitioning for this emergency variance, the district reserves its position subject to the evidence and testimony provided here today and the timeline that was provided this morning. Thank you.
Thank you. Okay, you can go ahead and present your first witness, sir.
Okay, I would like to present Peter Saxton, please.
And please spell your name for us, give us your title and the fact that you did take the oath.
Yes. So my name is Peter Saxton, Peter, last name Saxton, S for sugar, Axton. My responsibility is of Director of Plant Operations. I am the site manager in Rancho Dominguez in Compton. And yes, I did take the oath earlier this morning.
You can ask your questions of him.
So, Peter, on the 25th, when I came to you and told you that the RTO would not reach the temperature, your response to that was?
Yes. So when we became aware that the RTO was not operating within the permit conditions, so on Thursday we ceased the operation of the process operation. We ceased manufacture, and we did not run the VOC generating process. On Friday, we continued in that same state where we were not operating, and conducted the root cause investigation to determine why we had the situation that we did. And as stated in the timeline, we then at that point discovered what we believe is the root cause here, that the beds, the regenerative beds within the RTO were not in the correct condition, and they had suffered some damage. And that's when we initiated planning for the repairs to bring it back to the condition on a short-term basis that we're currently in now.
Do you have any more questions for him?
Let's see. What was the impact that had we been down for a number of days that would have been on the company?
Yeah, so our facility manufactures specialty adhesives that are used for the manufacture of electronic components and electronic component assemblies. That goes into a number of different industries, but most importantly, goes into defense-related industries, defense subcontractors, and allows them to fulfill government contracts that they have from the Department of Defense. Many of those orders that we receive are covered under regulations which are known as DPAS, which are Defense Procurement Allocation Services, and which means that we're legally obliged to fulfill those orders. And as I think all present here today can acknowledge, the very high demand for such materials by the defense industries at the current time. So not being able to operate the processes that feed the RTO has a significant impact to the fulfillment of those orders, which are needed for the Department of Defense.
Madam Chair, may I interrupt for a second?
Well, why don't we do it in the correct
It's more of a
protocol?
clarification because they're asking for retroactive variance. So I think it need to be clear to them, we do not grant.
We don't do retroactive.
Yes, which,
It's from this
it
point
appears
forward.
that they are in compliance right now with the temperature. So,
Yeah, so may I respond to that? So the data shows that we're on compliance as of this moment. What we don't know is the effectiveness of the repair that we completed last Wednesday, and for how long and how robust that is going to be. So what we have done and continue to do is monitor the operation of the unit. At this point, the data is showing positively, but we don't know for how long, and don't have confidence in that at this point in time.
All right, I'm going to ask for clarification from Ms. Lee. Is it your opinion then that they are potentially out of compliance? Are we going to go forward with this? Or based on the fact that they are in compliance today?
So all I can say, based on the evidence and testimony provided by the facility representatives, is that they have reached temporarily the minimum operating temperatures required under the permit, but they cannot testify that they're assured that they will be able to continue to meet that and want to continue to monitor. As such, they've requested a temporary, or I should say a limited variance for 30 days, so they can assure that the temperature will continue to be meeting the permit requirements without need of having to come back to this board for an emergency if it drops within the next 30 days.
Okay, so we can go forward.
No objection to that.
Okay. All right, so with that, did you have any other questions for this witness, sir?
No, I don't.
Okay, Ms. Lee, do you have questions for this witness?
Yes, thank you, Madam Chair. Mr. Saxon, I'm looking at the timeline that Hinkle provided, marked Exhibit 1. And particularly on Thursday, January 25th, Friday, January 26th, this exhibit states that the decision was made not to run the unit. I'd like to clarify, does that mean that a decision was made not to run the RTO, or the RTO as well as all VOC emitting equipment that's vented to the device?
Yes, thank you for the question. So what is meant by the unit is the VOC emitting processes feeding the RTO. We
Right.
were we were troubleshooting the operation of the RTO, but we're not emitting VOCs to it.
All right, no further questions. Thank you.
Board members, questions for this witness? Mr. Balagopalan?
yes, Mr. Graves, your timeline showed Monday, the last date here, you had 1610. What was it, Tuesday?
So yesterday, it was
Yesterday.
above 1600 as well.
And today you're operating also above 1600, to your knowledge?
I haven't been to the plant as of yet, but I haven't gotten a phone call neither, so I would say yes.
So technically you are in compliance with the permit condition of a minimum of 1600 degrees?
Yes.
And you understand that we don't grant retroactive variance, right? It's moving forward from today is when the variance is granted.
So
Which I
no,
stated.
I didn't know, but I hear you now. Yes.
So you still feel you need a variance?
Yes, sir.
Why?
Because I don't know if the repairs that were made were actually going to hold for the time. And then if they don't hold, so if the temperature drops, it's going to drop fast. And for me to put another petition in would take another amount of time. And by that time, I might have it back in compliance again. And so running back and forth takes your time and mine as well.
No, I understand that, but when you did the repair, and I'm assuming, okay, let me back up a little bit. Who did the root cause analysis for you?
Richard.
And he's from,
He's from Hinkle as well. He is our maintenance manager, and I'll let him introduce himself.
all right. So you didn't have Alliance, the manufacturer of your equipment, in there? Did you have them in there also?
Yes.
So they also assisted Richard in doing the root cause analysis?
Oh, yes.
Okay. And their finding was that the catalyst bed were damaged
Yes, that the beds were
and to
damaged.
replace them, so
They repacked them.
they repacked.
They repacked them.
Or not replaced?
No, not replaced. That's why it makes me a little nervous. Yes, they repacked them.
Okay, but since then that's the only root cause?
Yes.
They found that the catalyst bed need to be repacked?
Yes, but I would rather the maintenance manager
Sure.
answer your questions.
All right, I'll wait then. Yeah.
Okay.
Okay, then I've no further questions. I'll have that. When you introduce him, I'll ask him the question.
Okay.
Thank you.
Any other board member have a question? Mr. Pearman?
Has this RTO failed in the past?
Not to my knowledge, no, sir. It would be better. I've only been working for the company since January the 8th. So it would be best that if one of the gentlemen here answer the question.
And you show, for example, on Thursday it was 1629, Friday 1606. Those are averages, correct?
Yes, sir.
Is that kind of range typical or unusual, that it would be 23 degrees higher one day than the other?
I would let the maintenance manager,
All right,
I'll defer to him.
Would you have a question, Dr. Abraham?
Sure, I can ask. So Peter, remind me, how long have you been the Director of Plant Operations?
Since June 11th last year.
Last year, okay. So during your tenure as the director, any concerns about maintenance schedule or whether any of those actions, items were being completed or not being completed, or failure to maintain the equipment properly?
No.
Okay. And prior to you coming there, was there any sort of historical information or data given to you about the condition of this equipment, including the RTO? Anything that could have happened, any incidents prior to your role as the director?
There was nothing indicated to me around failure to perform maintenance or failure to maintain the condition correctly.
Okay, thanks.
Any other questions for this witness, board members? Okay, you can go to your next witness, sir.
Okay, I would like to, Richard Avalia. I said your name, last name. Okay, he is the maintenance manager.
Please spell your name.
Hi, I'm Richard Avila with Hinkle, Maintenance Facilities Manager, RICHARD. Last name is Avila, AV is in Victor, ILA.
I'm sorry, what was your title again?
Maintenance and Facilities Manager,
And how long have you been there?
23 years.
So you're the guy who knows everything.
That's why they brought me.
Okay, all right, you can ask your questions, sir.
Oh, Richard, was Richard, when we did the root cause analysis, who was there and how was it determined what was the problem with the RTO?
When we started the root cause analysis, we were in contact with Alliance. We were communicating over the phone. We couldn't make a solid determination as to what was malfunctioning on the RTO. So there was a service call put in with them. They showed up later in the evening. They did their evaluation, and through the airflows that they were getting and the loss of heat in bed A compared to bed B, they determined that the bed A had been compromised. And it was recommended that we open the unit up and go ahead and inspect the inside of bed A and bed B to see how bad the compromise was. So that was scheduled with the necessary materials that needed to be ordered to be able to do that. Then that was scheduled to get done as soon as those materials had arrived.
Do you have another question for him?
Yes, Richard, the packing of the material, is that a long-term fix or is that a fix that will last for a certain amount of time?
So per Alliance's recommendation, it is a temporary fix. We are actively getting a quote from them to have the beds replaced entirely, bed A and bed B, due to the compromise in bed A.
And then it was asked earlier, are the temperature swings that were reported on Thursday, Friday, and Monday, is that typical?
Yes, that is typical due to the outside. A lot of our clean rooms are 100% fresh air. So due to the conditioned air coming in and how many of the processes that we were running at one time, you could have a higher airflow from, as an example, we could be running anywhere from 10,000 CFM day, and it may, depending on how many processes we're running, we could go up to about 14 or 15,000, which you might see a little bit more drastic swing that way due to the air going across the beds.
Okay, I have no further questions for this witness. I would like to state that during the 2 days that we were down, both Thursday and Friday, the 25th and the 26th, there were no odor complaints that were registered to the AQMD.
Are you through with your question of
Oh,
this
yes,
witness?
I'm through. Yes.
Okay, Ms. Lee?
Thank you, Mr. Avila. Could you give a brief description of how the temperature is measured and recorded for the RTO?
We have a Honeywell recording and graphic device that's used, and it's taking a snapshot of the temperature every minute.
And is that recorded electronically?
Yes, electronic digital.
And around how long would it take? Is there an alarm or some kind of notification when that temperature, minute by minute temperature recording falls below the 1600 degrees Fahrenheit?
At this time, no.
So around how long did it take from that recording until the facility was aware that the temperature dropped below the permitted limit?
We were notified, or we did a systems check. I would say, I can't say how long it had been there. At that temperature, we found it going below. But it was reported to us on the 24th by a technician of mine that it wasn't reaching temperature midday, and we took active precautions then.
So while you can't give a definitive maybe length of time, the same day that the temperature dropped below 1600, you were notified?
Yes.
And the Exhibit 1 refers to average temperatures, but are you aware that the permit requirement refers to a minimum operating temperature?
That would be.
So yes, I do understand that the minimum is 1600, but the temperature swing so much due to the outside temperature. That is why I put the average. There are some temperatures that are much higher than 1600.
Okay, but when you say the average operating temperature was above 16, does that also mean that the minimum temperature was above 1600 on these days listed 21, 22, 25?
I would have to go back and look at the data. I do have all that data, and I would have to go back and look at the times that we were actually operating it to make sure that it was within the permanent range, yes.
And so you're aware that in order to come into compliance, the minimum temperature, even according to the minute by minute recording, must be 1600 degrees or above?
Yes.
And not an average, correct?
Okay, yes.
Just to go back to the good cause findings regarding reasonable control and diligence, You had attached to your petition a maintenance checklist. I believe that was dated in May 2022, but could you briefly describe how often the facility does a thorough maintenance check on the RTO?
We have a thorough maintenance check done by Alliance once a year.
And when was the last check done on this equipment?
July of 2023.
And at that time, was there any issue identified with the beds or with the temperature?
No, not at that time.
Would it be safe to say that the facility wasn't able to prepare for or predict that this temperature drop would have occurred?
Yes.
And given that you had testified earlier that the packing or repacking of the bed is a temporary fix, is it the facility's position that they need additional time to monitor in order to ensure compliance?
Yes.
And is 30 days sufficient for you to complete that monitoring and to assure compliance has been achieved?
Yes.
And lastly, you had referred to a timeline for an effort to replace the regenerator bed. Do you anticipate that there will be any need for additional variance during that time?
No.
No further questions. Thank you.
Thank you. Sir, how long would it take you to get that data that you're talking about so that we can know whether you were at a minimum?
It would take me a day.
A day? In
Well-
other words, you don't have records back at your office?
No, I do. I have them back in my office. So later on today?
Well, we were looking for something a little bit shorter than that, like within this hearing,
Oh,
like 10, 15 minutes.
oh, no, I'm
You would
sorry.
not be able to,
No, I
okay,
wouldn't be
so
able
you
to-
don't have that data readily available.
No, not.
Okay, all right. All right. Any other questions, board members, for this witness, Mr. Pearman? Mr. Ali?
So how old is this RTO?
Roughly around 12 years.
Has the media ever been replaced until this recent repacking?
No.
And since on one day at least, the average was 1606, which is only a 60-degree cushion over 1600, would you think it's a reasonable possibility that on that day at some point it might have dipped below 1600?
It could be a possibility.
Do you think it's a reasonable possibility, yes or no?
Yes.
Okay, good answer. And this might be a question, Mr. Saxon, but these contracts you're talking about for the defense industry, are they to be filled in 1 week, or are they 6-month production lags? Or what's the time frame of some of these contracts that, trying to understand why 2 days or 5 days is so destructive to filling a contract if the contract takes 90 days lead time anyway?
Right. So the lead time for orders is 6 weeks. However, at the current time, demand is exceeding supply, and we are already late with a number of orders.
Are your orders to the government or to private defense contractors when you refer to that?
To defense contractors who are fulfilling contracts with the government.
All right, thank you.
Okay, you had mentioned that this RTO is 12 years old. Do you know what the average life of that equipment is?
Per Alliance, the average life is 15 to 20 years of the bed, for the bed media.
Okay. What about the other components?
They're 20 to 25.
Okay. But that one is close to its life?
Correct.
Okay. All right, thank you. Any other questions? Mr.
Yeah,
Balagopalan?
Mr. Villa, you mentioned you do yearly maintenance. The report that you submitted with the petition was for 2022.
Correct.
There is a 2023 report also?
There is. When we had got it, we got it over to AQMD, but I'm not sure, maybe it didn't make it on time to this, but yes, we do.
Okay, so And that, as Mr. Payman, I think somebody asked, that report indicated there was no issues with the bed at the time.
That's correct.
And, okay. Now, the temperature right now, I think Mr. Graves mentioned that it was averaging, there was, because at times the temperature is much higher than 1600, and the average was still above 1600. But you cannot conclusively tell us that at any point it was below 1600.
Yeah.
Okay. So right now, it appears from the 4 days you have operating it, you're in compliance with the permit condition. And do you expect that to continue, or you expect it, since you've replaced or repacked the bed?
We expect it to continue to be in compliance, but we are still, like we said, we're a little bit doubtful as to how well the repair worked. So we want to monitor it and make sure that we have that taken care of. That's why we wanted the 30-day.
And why were you, if the root cause identified problems with the bed and you repacked it, bed A and bed B too, right?
Just bed A.
Just bed A. So what causes concern that the temperature will dip?
Alliance did inform us that that the compromise could get bigger and cause this issue again, but they couldn't give us a timeline as to when we might see this.
Okay. So in the 30 days, you're not going to do anything to the beds, correct? Just to observe?
Yes.
And you mentioned that you plan to replace them entirely. When is that scheduled, or has that been?
We are still waiting on the quote from Alliance. We expect it early this week, so we can proceed with getting them a PO and putting a project together for that.
At that point, when you would shut down the unit, replace the beds, and then start it back again?
Correct.
Yeah. Okay. Okay. All right. Thank you, Mr.
Any other questions from board members?
Sure, I'll just ask really quickly.
Okay.
How many people work at this particular plant or location?
Roughly 130.
Okay, and are there any concerns about health or safety of the staff, employees, workers, or? No.
No.
No. And fire safety, is there any increased fire risk with any of what's happening here? Or,
No.
thanks.
Okay, anything else, board members? All right. And that exhausts your witnesses. Okay. Did you have a redirect, Ms. Lee?
No, and the district has no witnesses.
Okay. All right. With that, I don't know whether you're aware of how good cause is established. Do you have a copy of the findings for good cause and what we normally ask the petitioner to do is to address the good cause requirements in the closing statements? It makes it easier for both you and for us to understand your situation. And so that's before I ask for that, I'm going to ask if there's anybody, Madam Clerk, if there's anybody with their hand up, either to make a statement or provide testimony.
Currently, Madam Chair, there are no members on Zoom. There appears to be no members in our public audience for comments or testimony.
Okay, thank you. So what will happen is that you will make your closing statements on good cause, as Ms. Lee will also make her closing statements, and then we'll deliberate in reference to good cause. And if you can make good cause, then we'll go into the 6 findings for the merits of the case.
Madam Chair, I'll make the final statement.
Okay.
So I think we've explained the sequence of events. We did have a period where the operating temperature did or was likely to have fallen below the operating condition of 1600, which satisfies good cause finding number one. We are also not confident in this time, without the additional data that we'll collect over the coming period, that no further violation is not imminent. And that is the reason that we're asking for the variation for 30 days, such that we can collect that data. We did not have indication that the ceramic media in the regenerative beds was going to fail at the moment that it did, and therefore we could not have reasonably avoided that. The expected lifetime of the equipment is still within the manufacturer's guidelines, and so in this case, it does appear to have deteriorated prematurely, and that satisfies number two. We have exercised due diligence in our root cause analysis, as well as submitting the petition as soon as we practically could. We've obviously acted with all due haste since the events that began on the 24th, which have led up to this hearing date here on the February the 7th, filing the petition at the earliest opportunity on actually January the 30th. And in terms of, and that satisfies number three. And in terms of number four, so the denial of the petition today of the emergency variance will obviously have an adverse impact to the fulfillment of provision of proprietary specialty adhesives for the manufacture of electronic components and electronic assemblies, which are critical to a number of industries, including and not least materials that are required by the Department of Defense for their critical needs at this time. And that satisfies number four.
Thank you. Ms. Lee?
Thank you, Madam Chair. I'd just like to make some additional clarifications to what Mr. Saxton had testified to. So it is the district's understanding, based on the evidence and testimony that we have before us, that as of January 24th, the RTO had dipped below the permitted limit. The facility had made efforts by, turning off the equipment, did a root cause analysis. And currently, we don't have definitive data other than averaging that they've come into compliance. So more likely than not, we can, on the basis of the information we have in front of us, can support that there is sufficient evidence that the petitioner is or will be in violation, subject to the good cause finding number one. In terms of whether the facility acted diligently, we do believe within 4 business days of identifying the issue and trying to fix it, filing an emergency variance demonstrates diligence. And finally, it may be premature for me to bring this up, but I would just like to suggest, if this board finds good cause, in order to have further assurance that the minute-by-minute data is being monitored, to add a condition to provide reporting to the district if the temperature drops below, if and when it drops below 1600 degrees by the minute. Nothing further. Thank you.
Okay, thank you. All right. Board members, we can go ahead and start deliberation on that. Mr. Pearman?
Sure. I think in terms of good cause, they did act diligently, demonstrate adverse impacts to the public if the variance is denied. It was unavoidable, not due to their fault. I think that we can find that they've met the requirement for emergency treatment, which involves in any consideration that there's a violation currently or imminently or reasonably likely. Testimony is that even given the 1-day average of 1606, it was probably below that at some point in time, which itself would be a current violation. And therefore, I think that we can find the good cause here.
Thank you. Any other comments, Mr. Ali?
No, a good cause was indeed established. And I think that the testimony from both sides underscores that point.
Thank you.
I can make the
Mis-
motion.
Mr. Balagopalan?
Yes, I'm not, I think they were, I can make the first finding, but I think they were diligent and they filed and they shut down and they did the root cause analysis, all the steps that they needed to do to come into compliance. But they are all indication. I haven't seen any data to show, provided to show that they are, the average was averaging 1,500 to 1,700 and the average was 16. There was no data at all in, from what I see, you have 3-4 days, and in fact, if we stop the hearing, ask you to call your facility, they probably will may tell you that they're still operating above 1,600, and part of the conditions say you're in compliance if you have 5 consecutive days of 1,600. So I think the good news is, in my personal opinion, you're not in violation. You don't need a variance. You don't need, you have come into compliance with the condition. And for that reason, I cannot find good cause to grant you a variance, hedging you just in case you get out of compliance, because you have done all the necessary. You've got the vendor in, you replaced the beds, you looks like you've solved the issue, and we don't do retroactive. We're only looking at prospective, from forward. So in my opinion, you don't meet that one finding with that you're in violation or will imminently be in violation. For that reason, I cannot, find good cause.
Thank you, Mr. Balagopalan. I don't agree. I agree with what the district had mentioned earlier, the fact that we don't know the days that they actually did go below 1,600 based on the fact that these are averages. That's number one. I appreciate the fact of the guideline or the timeline that helped us very much look at a snapshot of what was going on. But the fact that this equipment is also near its manufactured end of life, I also agree that they have the potential of going out at any time. And as they're the ones who are there telling us that they are concerned about that. So I take that very strongly, the fact that I think that they may be out of compliance at any point in time. And the fact that it's an average that they have been taking and not an actual number of the 1,600 per the permit regulation. I feel that they have met good cause and that we should grant this, because I think if we don't, as was mentioned earlier, they may have to come back to us in a very short time. So with that, I would very much support good cause on this and then go on to the 6 findings. Any other comments? Okay. All right. Anybody want to make the motion?
Yeah, I don't mind making the motion.
Thank you,
but
Mr.
I
Ali.
just wanted to take into account what the counselor stated. So on condition 3, proposed variance condition 3, so what we add by the minute?
That'll be after the 6 findings. We have to
Okay,
find the
okay.
conditions.
Okay, all right, so at this point, so we're gonna just write the,
Good cause.
okay, good cause. Let me see, Mr. Balakapalan has a nice little cheat sheet here, okay. All right, here we go, all right. In the matter of facility name Hinkle U.S. Operations Corporation, case number 4818-1, I move that we find a good cause to proceed with the hearing for an emergency variance and absence of notice to the public based on our discussion and ability to make the findings for good cause.
Second.
Okay, any discussion on the motion? All right, let's go ahead and vote. Mr. Balagopalan?
No.
Mr. Pearman?
Aye.
Mr. Ali?
Aye.
Dr. Abraham?
Aye.
And I also vote aye. So it's passed that we can go on to the second portion of this hearing for the 6 findings. And we're going to proceed basically in the same format. We will go ahead and move all of the evidence, statements, and exhibits from the good cause to the 6 findings as well. So, sir, we can go ahead and start with your opening statement for the 6 findings.
So ma'am, I only see 5. Oh, that's the conditions. Oh, I'm sorry.
It's the one at the top there.
So Madam Chair, perhaps maybe we can do a 10-minute caucus so that the gentleman,
Would you like about 10 minutes?
Oh, yes, please.
Okay, we can do that.
Okay, thank
All right,
you.
we're off the record for 10 minutes. Good to go?
Yes, we are. Thank you for the time.
Certainly. All right, so you can go ahead and make your closing statement based on the 6 findings. And have we already asked for any members of the public?
Not on the 6 findings. This would be the opening.
I'm sorry, yes.
So we haven't, and currently there are no members.
Okay, thank you. I'm getting ahead of myself here.
Okay, thank you. So I'd just like to, from the prior hearing, just reiterate, our current state. So at this point in time, we have completed a short-term repair based on the manufacturer's findings. And it is uncertain at this point whether that has restored the operation of the RTO to the condition to which it was designed and for how long that will be in place. And so without further data and also without a longer period of data, we're uncertain around what the minimum temperature will be that we will obtain from the continuous monitoring of that data. During the variance period for when it is granted, if it is granted, subject to the conditions that variance conditions that have been proposed, which Henkel can accept all of the 5 conditions as described. We will, in particular, operate the unit, the RTO, at the highest operating temperature that it can achieve, and thereby assuring the maximum possible potential to destruct the VOCs that we are operating to that process. I'd also like to highlight that the inability to run the unit as described would have both harm to supplying the essential products which are sole sourced from this location and are not able to be produced by any other location because they are the ones that are qualified into the applications and processes that our customers and defense contractors are purchasing. And so if we were not able to produce that, that would cause harm both to the business and to the end users of that material. I think that's all additional information that I wanted to provide at this time, but obviously open to answer any questions that are necessary.
Thank you. Ms. Lee?
Thank you, Madam Chair and Board. We heard a lot of evidence and testimony already in the good cause portion of today's hearing. Just wanted to use this time to go over some of the points in the proposed condition. First is that the district had proposed that the device C45, also known as RTO, would in no event be operated at lower than 1,500 degrees Fahrenheit. Part of that was to ensure that the equipment is still operating at a sufficient enough temperature, what we would hope to perform the VOC destroying functions which it serves, but to further ensure that we have included condition number 4, which requires the petitioner to contact the vendor and manufacturer and to obtain a guarantee, if possible, of any excess emissions or what the destruction efficiency would be by operating this equipment at a lower temperature. And if it's such that it would be lower than 95%, then the district would consider this to be causing excess emissions, and the facility would be required to monitor, calculate, and pay excess emissions, so as to satisfy the variance findings. In addition, as was brought up in the good cause portion, the district would propose to add a sentence or a requirement to condition number 3. I could read that now or wait to the end. whichever the board prefers.
Why don't you go ahead and read it now?
Sure. So for current condition number 3, after the first sentence, the district proposes to add, the report shall also include the dates and time, if any, that the temperature recording system indicated a temperature less than 1600 degrees Fahrenheit, while C45 is in operation, period.
Were you able to capture that, Madam Clerk?
Yeah.
Thank you. Okay, any other edits that you are suggesting?
Not at this time, and subject to the evidence and testimony, the district is unopposed to the granting of a limited 30-day variance. Thank you.
Okay, thank you. All right, you can go ahead and have your witnesses make any other additional statements if you care to.
We don't have any other additional statements to make, but I would just like to ask a clarifying question around the additional sentence proposed for condition number 3. Providing the data indicating the minimum temperature below 1600 when you said the RTO is in operation, do you in fact mean when the process that is supplying the RTO is in operation?
Yes, thank you for the clarification. So I was trying to keep it short, but the best language would probably be while C45 is in operation, and then whenever VOC emitting operations occur within the permanent total enclosure vented to C45, it's the language after the comma in condition number 1.
Okay. Thank you for the clarification.
Thank you.
So we have no further statements.
Okay. All right. Did you have any other statements you wanted to make or any other of your engineers that you wanted to present?
The district does not plan to call affirmative witnesses, but we do have staff from engineering and compliance should the board have questions.
Okay. And you don't have any other questions for any of the members here from Henkel, correct?
Yes, one question.
Okay, go ahead.
Have you reviewed the proposed conditions that filed and marked Exhibit A?
Sorry, could you repeat that one more time?
Have you reviewed the proposed conditions marked as Exhibit A?
Yes, we have.
And are you in agreement with the proposed conditions, including the edits that were discussed earlier?
Yes, with the clarification that we just agreed upon.
Great. Thank you. No further questions.
Thank you. Board members? Any
Yeah.
questions? Mr. Balagopalan?
Yes, it's either for I'll ask Mr. Vela the question, if it's okay. How do you keep track of the temperature? Do you have a strip chart?
We have a digital reader that keeps the tracking of the temperature.
And so if you have to provide the data, how would you can download that data?
Yes, we download the data and
Data.
then we're able to convert it to a Excel sheet to provide to.
Okay. And to your knowledge, when Mr. Graves did the average, who did the averaging calculation?
I did, sir.
And you took the digital data into an Excel spreadsheet and did the averaging? Or how did you do the averaging?
Yes, sir. I took it from an Excel spreadsheet. I had Excel, a number of data. I actually did a min and a max, an average, a min, and a max.
Okay.
Yes.
You don't know what the minimum was? What did you recall the minimum temperature?
No, I don't remember any of the
Okay.
mins. I just.
All right. Condition number 5, Mr. Vila, says that compliance will be achieved when the petitioner maintains the C45 operating temperature 1600 degrees Fahrenheit or higher for a minimum of 5 consecutive days. When I look at the data presented in the timeline, 3 days at least here, while we're debating the average, and 4 days, in fact, yesterday too, it was above 1600, correct? Temperature?
Yes.
Yesterday's temperature. And potentially, do you know if the temperature today is above 1600?
I haven't been in the
The
plant.
plant.
I've
But if you were to call somebody at the plant, what do you think they'll tell you?
that when they first go to it, it may be at 1,600 when they first see it,
Okay.
right?
When you're operating the unit, when you combustion, okay. It's what, it'll be what?
Above 1,600.
Above
It could be
1,600,
above
okay.
1,600.
So in a way, you've met the 5 days, consecutive days. If we taking the averages, I don't know how the average was calculated. We don't have the minimum max data, but, so when do you think, how can you, going forward, if the variance is granted, what will be a criteria to say, okay, I've met the 5 consecutive days and I don't need, I'm in compliance with the condition?
We plan to do daily monitoring on it and be able to pull that data and look historically at every minute to see if we stay above the 1,600. We don't, well, that's how we want to be able to proceed with this, and that's why we're asking for the 30 days, is so we can collect that data and review that data, and if we need to make any further repairs to it, we're within this timeline to do so without going outside of compliance.
Okay, thank you.
I just want to make a statement there that what Mr. Balagopalan has asked you is for an estimate, an assumption, which I'm concerned that it's not fact and it's not actual evidence that we have in front of us or that you have in front of you. So I would be wary of that, and that's not what I would make my decision upon. It's only going to be the facts in front of me that I look at versus an assumption. Any other comments, Mr. Pearman? Or
First,
questions?
on item 5, I guess that's AQMD first, we're talking about the final compliance, maintaining operating temperature at 1,600 degrees Fahrenheit or higher. That does not mean average, correct?
Yes, thank you for the clarification, and it may help to add then a language when petitioner continuously maintains to make clear that this is not an average.
Good suggestion. And then, let's see here. What happens, Ms. Lee, on item 1, if they do go below 1,500 degrees? Are you asking them to shut down, or is it just that they'll be in violation because they would not be meeting the variance conditions at that point?
That's correct. Just as in any other permit violation or violation of a variance condition, the facility has the option to stop operating, or it can be considered a violation.
And then on item 4, help me understand that, because petitioner immediately contact the vendor. So that kind of means tomorrow. And then the vendor says he can't verify VOC at that, et cetera, et cetera. And then you pay excess emissions just for that day, for the whole 30 days. I'm kind of confused about how 4 works.
Sure. So condition 4 was an effort on the district's end to address, let's see, is it the 5th finding of the variance, which states that during the period of the variance, the applicant, oh, I'm sorry, it's the 6th finding. The applicant will monitor or otherwise quantify emission levels if requested to do so by the district. Typically, for some of these cases where district staff is able to quantify excess emissions, it's pretty clear, but this operating temperature is almost an analog for VOC destruction efficiency. And as such, we don't have certainty that operating at 100 degrees lower would go below that destruction efficiency without a source test. But for a 30-day variance, district staff did not think that it would be necessary to require a source test, nor probably could it be, reviewed and everything and conducted within 30 days. And so we were trying to find a way to still address public concerns of potential excess emissions by having them contact the vendor manufacturer, get the assurance. If they're not able to, then they're unable to quantify excess emissions, and we're willing to accept that.
So again, this would be a one-time effort to have the vendor try and verify that? as opposed to continuously day by day by day?
So that we're okay with putting a higher standard in there. I think we didn't want to limit, contact the vendor 5 times. Perhaps could add, make all reasonable efforts to contact the vendor and to receive a response, some kind of addition like that.
Well, I'm not necessarily asking for something higher. I just want to understand how you read it now. And the way it's worded now is it could be one time. And as you said, if they can't verify, you're prepared to live with that, is what you said. So I understood you correctly.
Yes.
Okay.
Mr. Ali?
It's just a question of the gentleman. So it's very clear to say, and we can easily conclude, you will not seek anything further beyond 30 days. Your objective is to have this repaired and for this to be a one-time scenario.
That's correct. So our intent, I mean, we don't intend to take up the board's time with coming back with additional variances, additional petitions. I think that we followed the manufacturer's recommendation to make the short-term repair. In parallel, we're pursuing the permanent repair, which will be the complete replacement of the ceramic beds with original equipment, back to as-built standard. That time period to do that will be done during the course of this year, but the lead time to plan and organize that, as well as obtain the necessary parts, is measured in months and not days and not weeks.
Okay.
And so it is our belief that the repair that we have is the best repair that can be done in the short term, but we don't have the data or confidence in the absence of that data to know that we will not be in violation during that 30-day period.
And that's fair. And I can actually applaud you for being honest and forthright. Just one last question, Madam Chair. The DPAS, the percentage of DPAS products generated within this facility or at the facility?
The level of orders that we have is in the range between 10 and 40% of our overall output.
So this facility is vital to our national defense apparatus.
That's a correct statement.
Thank you very kindly, sir.
Okay, also, in reference to the 30 days and the fact that we don't backdate the variances, so it would start today, the 7th, and 30 days would be March the 7th.
Understood.
Okay. All right.
Comment?
Yes, Mr. Pearman.
I mean, just a comment. Speak for myself. It's kind of a warning. Don't wait till 29 days and then you find out that you've got to do the complete replacement, then run in for an emergency or a new variance. I would be kind of unhappy if you did that under the circumstances. It seemed to me like day 15, they can't tell you for sure this fix will work. You need to rethink about a different approach. Because your notice now, there might be a problem and we may not look favorably on a last minute attempt to get an extension because now you figured out that it takes longer work. It turns out that may be a possibility. You should probably come in on a shorter, with some notice now to the public and get more time to do it right. Just a comment. Thank you.
All right, and
point,
one
Mr.
other
Parrish.
comment to supplement that. Next time, check that ex parte emergency box.
Oh.
Check that box first.
Then you just deal with me.
You gotta do the-
Okay. All right. Anything else? Mr. Balagopalan?
I have no question, but are we in deliberation?
Well, I don't think they have made their last closing.
They haven't closed.
Not yet. Okay. All right. So there are no more witnesses. So now, and there's nobody online that is asking to be heard, correct?
That is correct, Madam
Okay.
Chair.
All right. So now we can go to your closing statement based on the 6 findings.
Okay. Thank you. Thank you for the time. So I think that we have established through the evidence and discussion that we've had today that we have been and are likely to be in violation of the permit conditions of the minimum operating temperature And in the absence of data, we've explained why we've come forward here today, because we don't know and cannot know until there is more data to gathered. We have moved with all haste to file the variance. We filed it, and obviously the hearing date has been set 8 days after we filed the variance. And so, that amount of time, we have taken steps to conduct the short-term repair. We're monitoring continuously. We'll analyze the data. We've understood the conditions that have been proposed. And subject to the clarification that was discussed earlier in the hearing, we can accept those and we'll fulfill them. I think it's also been clear how the harm that would be to the country and to the public if we were not able to operate in compliance with the conditions that are stated, and being able to operate the air pollution control device that we have. So, in the absence of going through all of the 6 findings here letter by letter, I think that we've certainly established that all of those conditions have been met.
Okay, Ms. Lee?
Thank you. I don't have much to add without being redundant, but I can go over again the proposed changes if needed. Okay. No, not necessary. Okay.
I want to make sure that the clerk has everything. You have it verbatim. Okay.
Great. And in addition to the adding the continuously maintains in proposed condition number 5, I would just like to add that the district does take excess emissions very seriously, that, given though that this is a 30-day limited variance, which is why we were willing to offer a little bit more flexibility with that. But should this go forward on a regular variance or a longer variance, then the district reserves its right to request a source test to ensure that we're not seeing excess emissions or to quantify those.
Did you want to put that into the conditions?
I think it's fine if I just preserve that for the record, Madam Chair. Thank
Okay,
you.
Thank you. All right, now we can deliberate. Mr.
Can
Pearman?
I ask a question of District Council?
Yes.
Just to make sure that since they've checked for reclaim and Title 5, there's no issues there in terms of how the variance is phrased, correct?
No, not to my knowledge. As the district's variance would only, a hearing board's variance would only grant relief from district rules, but they haven't sought AOC here. So, no, thank you.
Okay.
I was going to add condition number 4 does not have a timeline when they have to pay the fees. Normally, there's a timeline to pay the fees with the variance.
Thank you. The district is not opposed if the board would like to include a timeline within 30 days after the expiration of the variance.
Yes.
Yeah,
Thank you.
it's reasonable. Okay. And do you agree to that?
Yes, we do.
All right. All right, now we can deliberate. You want to start, Mr. Balagopalan?
Sure. Again, for the reason I stated earlier, there's no data that was provided conclusively to say that they're in violation, and much. They brought data showing how they did the average calculation that showed they were below 1,600. I'll take that, but it appeared from when I was hearing it, like the good news is we are we have met the temperature, but we want a retroactive variance when we were out of compliance. So that's not what I heard. And from what the good news is, I think with the change in the beds and stuff, it looks like they're in compliance with the permit condition. They're, I'm going to assume they're 1,600 and above, and so to make the finding that the first finding is they're in violation or imminent in violation, I cannot make the finding because no data was conclusively given to show that this average was based on 1,500 or 6, that how the average was calculated. So for that reason, I'm going to oppose again the granting the regular variance.
Conversely, I'll go ahead and offer my comments. Conversely, there's no data that shows that they did meet that and that it was above. It's an assumption, it's an average. We don't have any data in front of us to make that decision one way or the other. That's one. My other concern is that they have defense contracts, and having dealt with those type of contracts, everything has to be perfect, absolutely perfect, for them to accept the product, for them to have the requirements of the company that's providing the product. 9 times out of 10, it's proprietary. So along with the other comments that they made in reference to they don't have confidence. I mean, if they don't have confidence that that piece of equipment is going to be consistent and they can rely on it, then I can't say that I would supersede that and say, well, I have confidence in it. That's, to me, it would be doing them a disservice. So those are my comments. Mr. Ali?
All right, ready to make the motion.
Okay. Any other comments regarding? Okay. Mr. Ali?
All right, in the matter of Hinkle U.S. Operations Corporation, the ID number of the facility is 157359, permit number 496380. I move that we grant an emergency variance commencing February 7th, 2024 and continuing through March 7th, 2024. This matter is pertaining to and in direct correlation to the rules and subsections as listed. Rule number 205, C42, and then E193.5 for the petitioner's equipment. The equipment in question is the regenerative thermal oxidizer, RTO, combustion chamber. And that number is with a direct correlation to the facility's ID number as well as the permit number. Facility is located at 20021 South Susanna Road, Compton, California, 90221. The condition of the variance shall be set forth in Exhibit A, which contains proposed variance conditions as presented and amended and accepted by both parties. Thank you.
Just to clarify, Mr. Ali's, the proposed rules, actually, they decided incorrectly 205. Should be, since they clarified reclaims 203B, 2004, F1, 3002C, 1 from permit condition E193.5. So 205 is a permit to construct. So that's not what they're requesting relief from. So that.
So you can accept that amendment if you'd like.
Okay, so I just want to be clear. So
It's 203B, 2004 F1, and
okay, very well.
3002
Accept that
C1.
amendment, not a problem.
Okay.
And condition, all those for condition E193.5.
But now E193.5 is.
Yeah,
Yes.
I haven't looked at it, but I
Seeking
assume it
relief
is.
from that. Okay, I accept that.
Okay, do we have a second?
Second.
Okay, any discussion on the motion? All right, not seeing one. Mr. Balagopalan, how do you vote?
I don't vote no.
Mr. Pearman?
Aye.
Mr. Ali?
Aye.
Dr. Abraham?
Aye.
And I also vote aye. So it's a 4-1, and thank you very much for coming before us so quickly. I think you recognized the problem right off the bat, and thank you very much for that timeline, as I mentioned before, and working with the district. And thank you very much to the district for making sure that you understood what the process was. So if you have to come before us again, you'll be a little bit more experienced, but we have excellent staff that provides good information to the public. So thank you so much, everybody. Thank you, board members.
Thank you.
And with that, the matter is closed, and unless there's anything else, we are adjourned.